Hi, I'm Dr. Rellis, and I want to provide you with some valuable information about family petitions. Maybe you, your family, or someone you know is ready to take that step. We're here for you to hold your hand and to take that step with you. I know there are many things that keep us from making the first step towards a family petition. Maybe the current political situation, the paperwork, the time, the fear. A U.S. citizen or permanent resident can petition for many different family groups. A U.S. citizen can petition their parents if they're over age 21. You may petition for a spouse. You may petition for your children. And you also may petition for your siblings, only needing to have one parent in common. You may also petition for your stepchildren, and if not married, petition for a fiance who you love and want to bring to the U.S. to marry. In contrast, a legal permanent resident may petition for their spouse or for their minor children or children over 21 who are unmarried. It's very important that you have an experienced, honest immigration attorney and legal team handling your petition. Please do not make the mistake of handing your life to someone who's untrained in this constantly changing area of law. A simple and minimal mistake could derail your case for many years, sometimes decades, and in some cases, things cannot be fixed. We know this because we have a large percentage of people that come to us that have had denials when they went elsewhere or tried to do this themselves. At Rellis Law, we work tirelessly on family cases every single day and have been helping hundreds of beloved family members remain with or reunite with their U.S. citizen or legal permanent resident family inside the U.S. I want to address some frequently asked questions about petitioning and bringing your spouse, parent, or child to the United States. Who is eligible to sponsor a spouse for immigration? U.S. citizens and permanent resident green card holders can sponsor their spouse for immigration to the U.S. However, there are different preference categories for immediate relatives of U.S. citizens as compared to relatives of green card holders, and generally the latter take longer. Is there a preference system for family-sponsored immigration? Yes. Family-sponsored immigration is subject to preference categories. Immediate relatives of U.S. citizens, being spouses, parents, and unmarried children under age 21, do not face numeric limitations. So there's no waiting time, but other relatives do fall into preference categories with annual quotas. So often there are longer waits to get your loved ones over. Can my family member visit the U.S. while waiting for the immigration process? Family members can visit the U.S. temporarily while waiting for immigration processing. However, they must qualify for and obtain a non-immigrant visa, such as a tourist visa, and adhere to the terms of that visa. What if my family member is already in the U.S. without legal status? In cases where family members are inside the U.S. without legal status, they may face complications, but there are various solutions for certain family members. That's why consulting with an experienced immigration attorney is crucial to explore the available options and address any potential issues to ensure that you get your application approved. Navigating the family-sponsored immigration process requires careful consideration of individual circumstances and adherence to immigration laws and regulations. Seeking the guidance of experienced immigration attorneys can provide valuable assistance to you to ensure a smooth and successful immigration journey for your family members to be together and spend all the joys of life together here in the U.S.